I'd like to welcome everybody today to this OxFirst webinar. Thank you very much for your strong interest in this OxFirst seminar today. We were extremely pleased to see over 150 people meanwhile registering for this webinar, illustrating the strong interest in the questions of damage calculation and IP valuation. It's extremely exciting for me to see such a huge and broad interest from people around the world, especially from the German legal profession, to learn and understand more about some perspectives on how to value damages in a German context. For those who do not know OxFirst is a law and economics consultancy based in Oxford and in London meanwhile, and we focus on all aspects around the economics of intellectual property and competition law. We have a very strong interest in the economics of standard essential patents and FRAND, and have acted as expert witnesses in court proceedings in the United Kingdom, in Germany, in Canada, and the United States, and also the Netherlands. List of country still growing. And we have also acted as economic testimonials and experts for the European Commission on various expert reports pertaining to the valuation of intellectual property and patent pools and patent aggregators. And we collect a series of damage calculation approaches across the planet. We have had so far covered the United Kingdom and Canada, the United States, obviously, and we're really happy to have now insights from an expert and professional coming from Germany. Yeah, if you have any interest yourself in giving a presentation, please get in touch with us. We love to hear from you. We see ourselves as an open platform. We run these webinars at least once a month. And yeah, if you're keen on intervening or making a point, let us know. We'd also like to let you know that we are planning our upcoming conference again, the Intellectual Property and Competition Forum, which will most likely be held in Vienna with the support of Austrian public authorities. With all of that being said, for those who really do not know OxFirst, check out our amazing website. We have a new logo, new slogan, We Value IP. And in that context, I'd now like to present our speaker. So our speaker is a longtime friend and ally whom we have worked with for many years, Dr. Dietrich Kammler from Taylor Wessing in Germany. He's a partner there in the IP and ICT team. He's specialized on patent litigation in that sector, but also in the healthcare sector and wherever there are patent disputes arising. I think Dieter has a very, very long, decade-long experience in this area. And I asked Dieter if he would be interested in giving a talk on damage calculations in a German context, and he agreed. And I'm really happy that he'll present here today. So I'll give the word to Dieter. Before that, I forgot in the last seminar, I made my disclaimer before the speaker, in the middle of the speaker's talk, because I had forgotten about it. So I'll say this time. The views expressed here are not those of OxFirst, of myself, of anyone affiliated with OxFirst. They're solely the cup of tea of Dieter. And probably even Dieter will want to make a disclaimer that perhaps the views expressed are not also totally his own, but that's his thing. Okay, Dieter, you have the floor. Thank you for joining us today.
So, thank you, Roya. I hope you all see my screen now with the presentation.
Nope.
Yeah. You should have it on your screen. I will, of course, as you said, Roya, I will present my private views on this topic and a few observations, but I cannot guarantee that every time I appear in court, I will take the exact same positions in the future. We have a number of slides, but don't worry, they will be highly repetitive, so
Dieter, it says private and confidential, but we are going to put this up on the internet.
Yes, that's
and make
no
this
problem.
Everything else then private.
That's absolutely okay. Okay, let's start. So I will give an overview of how patent damages are calculated by the German courts. I will run through the principles so that you understand where the German legal system and also the German judges who are now in the UPC come from. And in the end, I will give a short outlook how this compares with the rules we have in the UPC, where we, of course, have no legal experience at the moment. But from the UPC agreement, you can also see that there may be some room where this could be different compared to the German system. So first, the legal basis is Section 109 of the German Patent Act, and here it's Section 2, which is says that any person who performs intentionally or negligently, so with fault, patent infringement shall compensate the aggrieved party for the damage caused. So that is compensating the actual damage. Then it says when assessing the compensation, consideration may be given to the profit which the infringer has obtained. So that is the surrender of this infringer's profits. And the third one is the claim for compensation may also be calculated on the basis of an amount which the infringer would have been required to pay as equitable remuneration had he obtained permission. So that is the adequate royalty. So you have three options here in the German law. These are also linked into the general civil law. So generally in damage cases, you have to provide full restitution into the position of the plaintiff as it would have been without the infringing act. The plaintiff has the burden of proof for this. Our civil code provides facilitation of this burden of proof. So lost profits can be estimated by the court if they were likely to occur. There does not have to be full evidence. And also procedural law gives the court discretion in determining how the estimation of lost profits and so forth is made. So these are the three sections. You can read them in the handout. So as I said, the three alternatives we have in patent law are compensation for actual losses suffered, surrender of the infringer's profit, and adequate royalty. These have been established decades before the enforcement directive in German law. And from the German perspective, the feelings that this is also what we find in the IPRED and the enforcement directive. And this is how it's applied. They are usually from the German damage trial. I will not go into procedural details in this presentation, but just to give you some background how this works in practice. We usually have three stages in our trial. First, we have the initial infringement trial with an order for an injunction, the order to give information on customers, suppliers, and render accounts on past sales, revenues, costs, and profits for the infringing acts, and a declaratory ruling on damages. And there's a second intermediate stage in German proceedings where the plaintiff enforces the claim for information and accounting. And with the accounting, you can calculate the damages for each of the three alternatives. You can see what the actual profits of the infringer, you can see the number of sales if you want to go for adequate royalties and so forth. And at last, the plaintiff will, in a separate damages trial, sue for a specific amount of damages, which is calculated on the basis of the information received in the accounting stage. So what are the considerations before you start this trial? So the plaintiff has the burden of proof for the facts on which the damage claims are based. There are estimates as shown, but these estimates can be forward-looking, lost profits, potential future profits. That's where the court can make estimates, but the facts on which these estimates rely have to come from the plaintiff. They have to be proven. And that's why this accounting stage should really be used by the plaintiff. The plaintiff should not rush into damage proceedings without getting thorough accounting from the defendant and get the full picture and all the information you need to present a proper damage calculation to the court. The choice of the three calculation methods can be made and changed in the proceedings, even in the appeal stage, until there is a final and binding ruling or the defendant has paid the damages. So these are not three separate claims or rights. These are three different ways to calculate the same claim. The three methods are strictly alternative. The plaintiff chooses one of the three methods. you cannot have cumulative damages. You cannot have full compensation for own losses and then the infringer's profits on top. I mean, that is pretty clear, but you also cannot mix aspects of the calculation. For example, if the infringer had high loss, the patentee had a high loss, but the infringer had no profits, you cannot reduce the recovery of the lost profits of the patentee. So it doesn't work this way. Sometimes courts use another calculation method as a sanity check, and if they are very far apart, the two calculations, they would find for reasons why this is the case. There can be some reasons. For example, if the
Do you agree with
infringer, there have to be, yeah, if there are reasons, and also, of course, it's different basis of calculation, so the results can be different, and this is fully justified. Sometimes infringers give a product away for free, and they have no profit, but that's no reason not to give the patentee full recovery for his actual losses. There can be different choices for different infringing acts. So it's not just one choice, but you can choose different compensation for different infringing sales. For example, an infringing sale in a tender situation where there were only two competing parties, there it can be attractive to go for infringers' profits. Also for freely given away free product samples that were distributed in the market, you can go for adequate royalty. And then you can go for infringers' profits for the sales where the infringer actually made profit. And of course, you can always ask for compensation for additional costs like fact gathering, investigators, test purchase, lab reports to prove infringement if this is not covered as part of the recovery of legal costs. So let's now go into the three calculation methods. So that's where the real music is here.
If I'm on the right slide.
Pardon?
Am I on the right slide or which slide?
We go for lost profits now. That's slide 13. So lost profits are, first we go to the burden of proof. That's a problem with lost profits. There's a high standard of evidence. So the plaintiff needs to prove existing customer relationships with the purchasers of the infringing products. So you get the names of those purchasers from the accounting stage, but then the patentee and plaintiff would have to show that he would actually have made the sale to those customers as well in the absence of the infringing product. And you usually also you would have to show an impact on own sales by the infringing product in the market. This is very difficult. And as I already said, in limited markets, that's possible. For example, a good example was the tender for the new German Army's assault rifle, where there were just two competing companies for this, and the one infringed a patent of the other, and the patentee came second in the tender. There it would have been clear in the absence of the infringing offer, the patentee would have made it and sold the rifle to the army. In the end, the infringing party was disqualified from the tender, so there was no damage trials in this case. Then there are some markets, highly specialized products with very few competitors who all know each other, very few customers like railway systems, passenger planes, where you may be able to go for infringers for actual lost profits, or the first launch of a generic drug is a practical example. If the entire active ingredient was not generic before, or the entire indication medical use was exclusive to one patentee, and you really have the first serious competition for an entire field of application. You can also go not only for lost sales, but also profit lost due to price erosion. If the competitor's product is substantially cheaper and the pricing in the market goes down. This is something observed in with the first launch of a generic drug. There have been these cases. I'm not aware there really have been published decisions, because these cases have often been settled because it's very tough to adjudicate in the end. So the calculation of lost profits, here you have to keep in mind it's compensation for lost profits and not for lost revenue. That means the plaintiff has to present and explain the profit margins of the own product. So what would have been the profits made with the own sales? That requires disclosure of internal calculations, of cost structures, and you can file these documents under seal, since the trade secret directive was implemented in Germany, but there will always be at least 2 employees of the infringer who's the defendant, who will also see it. There's no attorney's eyes only principle in Germany. That's not possible. So the competitor will always get access to this, even though it's heavily restricted and cannot be used legally for other means. So that's something most patentees want to avoid. If you go down that way, economic experts can help to really break down the cost structure and show what the patentee's profit in that case was, of course, because it's sometimes complicated for lawyers when it gets into the accounting to understand how you break that down, take it apart. As I said, there's not much case law in this field, and the calculation will likely resemble the calculation of infringers' profits, to which I will come in the next chapter. But first of all, of course, where it plays a role, compensation for other costs, I already mentioned investigation, testing. There can be confusion in the market if there are suddenly several competing products where there should only be one. So this may require increased marketing and advertising efforts to restore the monopoly of the patentee, not only in law, but also in the minds of the customers on the market. These kind of additional costs can be compensated as actual losses, and that is where this calculation method is established. Lost profits do not automatically carry interest, only if the plaintiff can either show that there were increased financing costs in the company due to the lack of the profits they would have made with the product, or if the defendant was put into default, either by filing the case, which automatically triggers default, or by a specific warning letter. And then there is also in the Article 60 in the UPC now, the compensation for moral prejudice. That's of course also possible in theory. It's also in the enforcement directive, but this had practical relevance only in copyright cases, and German courts so far didn't have the fantasy to see moral prejudice compensated in
We had a previous
cases.
webinar with Professor Tom Cotta, who also joined the call on the damage calculation in the United States around moral prejudice. It showed up to be a fairly complicated matter. This is not straightforward. I mean, it's already tricky to calculate patent infringement damages in that context, but moral prejudice is very difficult. Do the German courts offer further indication in this matter, or where do they stand on that?
So I haven't seen cases for that, and I think it had not been tried so far. And German courts like to stay away from overly complicated calculations and keep it simple. And that's why it would probably, I would assume, would not meet with great sympathy at the moment in a German court. Would be a hard fight if you would, and it would have to be a special case, I think. So let's go to the next calculation that is far more popular, even though it's the second one in the list. It's far more popular with German patentees. That's infringers' profits. So the calculation of infringers' profits is based on 2 steps. First, determining the infringer's profits with the accused product, obviously. Then a second step is a determination of the contribution of the asserted patent to the sales and profits with the accused product. So the infringer's profit, that is important to keep in mind, is not the actual profit of the company with the product in the balance sheets or in their own books, but it includes contributions to overhead costs. So in the last millennium, companies always were able to come up with a calculation where they made only losses with the infringing product and deducted a lot of overhead costs. Then the Federal Court of Justice cut this off and said contribution to overall overhead costs is like profit, because it frees money that can be spent elsewhere, and it helps to generate income which is actually available also for distribution of profits. And that changed for a short time. There were very, very high damage awards until the courts then cut it back down. And the infringer's profits still can be significantly higher than the actual profits. That has to be kept in mind when you look into the calculation. The plaintiff has the burden of proof for the infringer's revenues, and that has to come from the accounting stage after the initial infringement trial. The infringer has the burden of proof for the deductible costs. So if these deductible costs are disputed, which also came from the accounting for the revenue and profits, then the infringer has the full burden of proof. And if a defendant does not engage in that process and does not disclose, does not open the books and show the actual costs, we've seen this great hesitation to really open this up and just argue about the costs associated with the products, then infringers' profits can become excessively high. In one case, we've seen 60% of the gross revenue being assigned to infringers' profits because the infringer simply did not engage in the calculation. So this has to be kept in mind. It's unpleasant to have to open the books as the infringer, but that's the only way to get this number down. Infringer's profit carries interests 5% under German commercial code. Will not go into the details how this, what the reasons for this are, but that seems a accepted practice at the court at the moment. So if we go further down into the details of the calculation, the basis are all the revenues generated with infringing products and services. This is the entire product and not just infringing components. So you cannot point to the SSPPU, the smallest saleable patent practicing unit, but it's the entire product as it's put on the market. And in addition, there can be income from the sales of accessories, spare parts and services or repair of the infringing products, because this revenue would not have been made in the absence of an infringing sale. And then literature discusses whether you should also be able to claim damages for so-called, where the infringing product was a door opener for other projects. For example, if you sell patent infringing notebooks, you may also be able to sell keypads, mouse pads, monitors, and so on. Usually comes from one supplier. So these would be independent technically from the infringing product, but this is kind of tag-along business that comes with the sale of an infringing product. But that's disputed and not accepted in the court. What is accepted is spare parts and genuine accessories, which are useful only for the infringing product. Then comes the deduction of the variable costs. That's the key part where we go from infringers' revenue to infringers' profits. The working assumption is that you start from an established product. So you cannot deduct any costs for developing the infringing product, for testing the infringing product, for certifications and so forth. These are sunk costs anyway, but they cannot be deducted. So even if you did not even earn your investment back on the infringing product as defendant, there will be infringers' profits because all these costs will be simply ignored. The patentee does not have to accept a reduction of his claim because of the investment of the defendant in developing the infringing product. And then only variable production distribution costs directly attributable to the infringing product can be deducted. This is material, tools, energy, consumables, also distribution logistics and marketing. And personnel costs can be deducted if they are clearly linked to the making of the to the infringing product. So in old case law, defendants would have to show that they would have terminated the employment agreements in the absence of the infringing product. This is very, very strict and is no longer a requirement. So nowadays, if you can show that you would at least have reassigned the personnel to other products, or that you have a clear calculation where you see which kind of full-time equivalence was dedicated to the production of the infringing product, that should be evidence to get that acknowledged as variable costs. The same with
Dieter,
machine
sorry.
costs.
So, for example, if the patent reads only on a part of the product, you won't fuss around, you say, with figuring out what the value of this part of the product is. You just take the value of the end product, end of story.
At that stage, at the first initial stage, that's the case. If only the infringement is really only one component that is different, but it's one product, you would start with the product as it is put on the market. But that is only the first stage.
Okay.
And so also for machines, you can, maybe if you show that machine time is really separately calculated in the system, you may be able to deduct that. But that is, you always have to have good reasons to show that these costs are variable and could have been lower in the absence of the infringing production. And there's no deduction of overhead costs, that is rent for production facilities. Only if there's one factory only for the infringing product, you may have a chance. And no administration costs, and of course not capital costs, or if you had to take a loan to put up the infringing production, that's not deductible. Then comes the second step. That's where the court determines whether there's a link between the infringement and the profits, whether the patent actually contributed to the infringer's profit, and what this contribution actually is, whether you can really say that this patent infringement is the true cause for the infringer's profits. And that was where we leave the really hard, proper economic calculation, and where we go from calculation to speculation, you could say, if you want to criticize it, because that's where the judges also exercise discretion in making estimates and are open to parties' arguments. So first of all, it's of course the significance of the patented teaching for the success of the product. There are groundbreaking inventions which really define a product, like a new pharmaceutical, a new drug, a new active ingredient, which really defines the product. And then there are of course complex products which use tens of thousands of patents, where one single patent is not really a case why the product is purchased. Also, a smartphone uses, I think, beyond 50,000 patents. Maybe one single of these patents would not be the reason for the commercial success, at least not alone. It contributed in some way, but not alone. And that is where the court gets in, and the judges just apply their right to make estimates. The infringer has to provide evidence on the alternative reasons for market success. So if there's nothing from the defendant and infringer, again, the share that is attributable to the patent will go up. So something that could be relevant here is own patents used in the product. That can be a reason to assign not all of the profit to the infringed third-party patent. Also, a strong brand recognition can be a reason why the product was attractive on the market. And special intensive marketing efforts can also be a reason. But there has to be evidence for that. This is again a part where there could be customer surveys to show that it was the brand is really what drives the sales, and not the innovative technology in the product. Again, this is for the infringer to make these arguments. And you can also point, when it comes to the significance of the patent, to non-infringing alternatives, but only to those non-infringing alternatives that were actually available on the market during the time of the infringement. So you cannot, after the fact, in the litigation for the first time, invent a workaround and say, oh, this is what we could have done. You really have to show what was available as alternative on the market. On the other hand, the plaintiff can point to reasons which speak for a significant contribution of the patent. That is, for example, if the infringer advertised the patented feature, that is a reason which could really point to a high significance of the infringed patent. Public reports about the patented feature. So you get praise for this feature for free in the press when you launch the product, but then you may have to pay for it when it comes to assessing the infringer's profits. and the use of the patented feature also in other successful products. All these can be reasons to show that this patent was really significant in the market and deserves a high share of the infringer's profit. Ultimately, as I said, this causal link feature will be used by the courts to adjust infringers' profits to what seems fair in light of the improvements provided by the patent in the view of the court. So there's always a subjective element or of opinion in there, which is not really hard science and calculation. But again, also here you really have to first understand the economic situation on the market and see what customers' preferences actually were and what drives them. So this is the infringer's profit, and this gets us to the adequate royalty. That's the kind of the baseline compensation you can get as a patentee. That's independent of the profits made by the patentee or the infringer. You have, of course, two steps. You have a royalty base.
Peter, I noticed in the beginning you said that iPad, is there not a difference here with the iPad? The iPad does not mention this, as far as I understand it, as a separate method.
iPad mentions the infringer's profit and the loss profit in one paragraph, kind of mingled together, and the adequate royalty as a second alternative.
Mm-hmm.
I'll come to that in the
Can you explain
comparison.
that whole relationship with iPad? That would be quite nice to understand, maybe. And also the issue around proportionality and dissuasiveness. That would be also nice and required. Correct.
Yes, I will come to that if in the comparison to the UPC, because of course German law has to be governed by IPRED, by the enforcement directive, but it's the German views that this choice between the three methods would be compliant, because the patentee can make a choice and can choose the most dissuasive method. But of course, you would think that each of the three methods also has to be proportional, but also dissuasive in a way. So we will see how this is dealt with in the adequate royalty. So the royalty base is determined in accordance with actual industry practice in the field. So you again cannot point to the smallest saleable patent practicing unit. It can also be a complex commercial product. And if there's no commercial licensing practice in this field, the court will likely look at the components which are actually characterized by the patented invention. This does not have to be the smallest saleable unit, but probably a unit inside a complex product which actually practices the invention. The royalty rate, again, is determined in line with commercial practice. So here you have a full reliance with the adequate royalty, first of all, on commercial practice. That is where license agreements, comparables have to be put on the table, and where you again need an economic assessment of what is comparable and why it is comparable, or where you have to make deductions or unpack license deals to find out what this patent was actually worth in a previous deal. But also you have to take into account the infringement scenario, which is of course different from a royalty, which is negotiated before you start using the patent. So if the patent was already reduced to practice and has proven its value in an actual product, that is a reason to charge higher royalties. That is accepted also in the field of licensing. That is a good and sound reason to ask for more than if you just have a recently filed patent and look for a licensee who first wants to try this in the market. Also a patent where validity and infringement have been confirmed by courts, that drives the value up very much. And everybody who has been in settlement negotiations or also in licensing negotiations knows that if you put highly relevant prior art on the table, then the royalty rates will go down. And of course, the other way, if the validity was confirmed in light of all the available prior art, the royalty rates will of course, go the other way and will go up. This can result in higher royalties than what you would have negotiated in advance. That is clear, and the courts have in Germany increased royalties on this basis. Munich Regional Court by 66% in one case, and the Düsseldorf Regional Court in several cases by about 33%. They also tried to argue that this should be like a flat top up without having regard to individual arguments, but at the moment we are working still with some arguments which you have to present in the case. And of course, there are cases of low price knockoff products where the royalty can be set independently of any sales prices or giveaways. That's also a special circumstance. So
what about the international licenses? So you have a comparable that stems from another country.
Yes, that's absolutely
What
possible.
about if it's outside the EU even? No, I don't know.
That's a good point. I would comment to the parameters, have it here. So every license, if you look for comparable license, every license which is also granting a right to German patent is relevant. So if a German patent is licensed in a worldwide licensing deal between US companies under US law, but it's also granting a license to Germany, then it would be a relevant license to a German patent, especially in international industries. You cannot just look at Germany and not look anywhere beyond, for example, in IT or telecoms industry. This would be nonsensical, and the same in the pharma space. There may be some fields where you license country by country, but usually it's really on a global basis. So you should look at licenses from elsewhere, and they are without doubt relevant if they also grant a license for the territory of Germany. If Germany is not in the deal, they could still provide some guidance, because if you compare it to other comparable countries, UK, France, US, you would usually get comparable royalty rates in Germany. Of course, the ideal starting point are existing licenses to the asserted patent. So if the patentee has own licenses, this can be a very good basis for calculating the adequate royalty. But keep in mind, this is not a friend scenario, so the patentee is not obliged to give the infringer a low royalty rate that was earlier offered to someone else. There can be discrimination. The patentee is free to charge whatever he wants. But of course, if there is a number of existing licenses to a certain patent, then there with the same range of royalties, there is some indication that this seems an adequate royalty at arm's length. Also, licenses to other patents, but between the same parties, are relevant because they are, of course, from the same industry, same field of technology, typically, and the same kind of players. So a lot of factors are already comparable. Then you would just have to see whether the license patents were really significantly different in that other license deal. Then there's also often the court cite the fixing of invention values by the German Patent and Trademark Office. This is a German oddity. So when employed inventors make an invention, they're entitled to some kind of royalty share as a special remuneration on top of their salary under German law. And if there's a dispute in an ongoing employment relationship, they can go to the arbitration panel of the Patent and Trademark Office. There both parties would present their views, and then the Patent Office would define the adequate remuneration for the invention. And one part of that would be to look at what royalty rates for the patented product could be. This has to be taken with great care because they don't have full access to a lot of royalty license agreements. They may have seen some license agreements, but these are only the ones maybe the employer wants to actually present. Also, they use guidelines from the Ministry of Economy, which are from the 1960s. They are no longer officially binding, but they're still used. And, for example, you get discounts for larger revenues, which is not necessarily the case in the industry. And often you just see royalties where, at least our feeling is it's sometimes rather at the low end. So this can be a hint because these awards by the arbitral tribunal are published in a handbook where you find a lot of royalty rates they found for different industries, but still it can provide some guidance, but it has to be used with significant care and sanity checking, and also, but again, the parties really have to engage and then present own licenses or other experience if they want to defend the case or argue the case one way or the other.
What about the matter of transparency? Because in order to use the comparables approach, you need to have a good idea of what is going on in the market. You need to get access to the whole licensing contract. You need to see what else they agreed upon other than just the rate. You need to know what happens. You need to know more, and you need to know more from a lot of different people. So how are the Germans intending to come to grips with that fact? And at the same time, that most licensing contracts are under confidentiality clauses. This is a contradiction in and by itself. How can the success of this method be assured in light of the fact that it runs afoul of a whole different philosophy to licensing?
That is indeed a big issue you mentioned. That is what we are struggling with, and the courts. And that is maybe also the reason why they go to the arbitral awards of the Patent Office in the absence of any better information. Even there, we don't know the parties, we don't know the patent. So it's you really, and to assess what you get, you really need to know a bit about who were the parties in the deal. Was there market power involved?
So
you need to know the patent, the invention, and you really need to know background. If you look at license agreements, sometimes there are cross licenses which you have to unpack. So you cannot take royalties at face value. There can be upfront payments. We've seen side letters, high royalties, and a side letter that said the royalty becomes only due after the first 200 million sales, which will never occur. So you really need more. And also you need to understand who the parties were actually to fully assess this. This is why really the parties in the litigation are so important. They really have to bring the agreements to the table. If they don't, then it gets very difficult and speculative.
So that's then very dirty data, basically, you get from the GPT or arbitration panel. That's very rough, dirty data where you in the end don't really know what happened. And that can only be in your last resort or something like that. If you really have no other method available, no other data available, then you take some extremely vague information about whatever someone possibly did, but you don't even know.
I mean, it's better than nothing, and the Patent Office does really an honest effort to collect this and publish on a regular basis, and at least it's based on some industry experience. But yes, you're right. It's really, I would not think it's reliable data. And from some cases in the book, we know that even the awards of employee remunerations were raised by a factor of 5 to 10 in later court cases. So it's also not a guarantee that this is always correct. So it's something in the absence of better information, but I would take it with care.
Is there an intention to change that? For example, in the United States, you have the SEC, and in Canada, similar authorities that ask to disclose licensing transactions over a significant deal.
That's a very good point. I mean, if you have SEC filings on license deals by parties, that is something you can, of course, also put to a German court, and that is there's more flesh to the bones if you know who the parties are and also probably what the patents were.
But there's no policy intention to do
there will not
like
be. So the courts are free to do whatever they want as long as they deem it right, and so they will whatever is cited to them, they will use that, and if there's nothing else, they will just use what is presented to them. So, and now the big legal issue with the adequate royalty is under the Enforcement Directive or IPRED, royalties have to be not only proportionate but also dissuasive. And if you can just infringe a patent and then pay the royalty you would have paid had you asked for a license in advance, then you have zero risk. And the Düsseldorf Court of Appeal put this to the European Court of Justice in the Jorn Hansson case. Maybe not the best case because it was a plant variety case. There's a European regulation on the protection of plant varieties, which also has rules on damages. And this was the basis for asking the European Court of Justice whether you can just ask for double royalties in case of a license in the infringement situation. If you go for the adequate royalty under also the Article 13 IPRET. In this case, the European Court of Justice said no and said this has to be assessed in the individual case, pointed to the fact that there are no punitive damages under the IPRET. There's simply no basis in this plant variety regulation. This was seen in Germany as the end of any top-up that is granted automatically without consulting the individual case. And then a bit later, the same European Court of Justice, but a different chamber in the OTK case from Poland, that's a copyright case, said, yes, you can have double royalties from infringers. And we feel that this is also concerned by the Jorn Hansson case. They cite 2 paragraphs in this case, which have a general reference to the enforcement directive, but not no discussion of the totally different outcome. So you wonder how this was done. They probably wanted to avoid referring this to the enlarged board or the general chamber in the European Court of Justice. But you have 2 conflicting cases. My takeaway is that you probably can ask for increased royalties if you at least provide some reason, as the German courts do. They could maybe be a bit bolder and go for double royalties, or at least a 66% top up in Munich that I would think would be in line with the European case law after the OTK case. There's currently no new established case law on that. Royalties are also subject to interest, and that's where it gets ugly for the defendant, because the assumption is that you would have to account for the use of the patent at least at the end of a contract year, and then pay within 1 month after the end of the contract year. So you would have to pay for 1 year by January 31st the following year. And if you don't do that, you would be in default, and that would be an interest rate of 9% above the ECB base rate between companies. So that means you get beyond 10% interest on old royalty payments. And if a case is pending for 15 years, you can imagine that the interest is sometimes more than the original adequate royalty for infringement in very early years. So I have also here printed the statements from the 2 cases, Jorn Hansson, OTK. And now I want to give just a quick glimpse at what will it be like in the UPC. Is this the same from the German perspective? I think the perception in Germany is sometimes that we can just do the same and just write Article 86 instead of Section 139. So Article 86 closely resembles the enforcement directive. It's even closer to it than the German article, Section 139. So paragraph 1 really says that the harm should be fully compensated. The harm actually suffered by a party should be compensated. And that means actual lost profits should be compensated. That's a general principle. Section 2 then says, yes, the party should be placed in the position it would have been without the infringement. That's the full compensation, restitution to the situation without infringement. But damages shall not be punitive, and the infringer shall not benefit from the infringement. A bit conflicting, and when it gets into details in paragraph 3, when the court sets damages, the court shall take into account all appropriate aspects, such as negative economic consequences, including lost profits of the patentee and any unfair profits by the infringer. and in appropriate cases, elements other than that, which is moral prejudice, for example. And then the second alternative, section B, is adequate compensation, at least the amount of royalties or fees which would have been due by if the infringer had requested authorization to use the patent in question. And paragraph 4 is about infringement without fault. So I'll come to that now step by step. So this is the enforcement directive. You will see it's very similar, but not entirely identical. We just touched upon that. So you have the articles 1 and 2, which paragraphs 1 and 2, which really set out the general guidelines. They don't mention that damages have to be dissuasive. And then you got two choices. That's the first difference to the German law. German law provides 3 distinct choices. The Article 86 provides just 2 choices. So you have the damages, which is the actual prejudice suffered, but taking into account unfair profits of the infringer and non-monetary aspects. So the separate compensation for moral prejudice, to deal with that first, that can be added onto lost profits or surrender of unfair profits. That would be the same under German law. It's just an independent cause for damages, but it remains to be seen whether this will be more popular with the UPC than with the German court. And the big question in paragraph 3a is whether there is still a strict separation between infringers' profits and lost profits of the patentee, or whether you can now mix the component, make a compensation for actual loss and a top up for excessive infringers' profits, which is not possible in Germany. You have Germany, you follow one calculation or the other all the way through. You can only divide it up for different infringing sales. Is it possible to reduce compensation for the patentee's actual losses due to infringers' very small profits? I don't think this should be allowed. There should always be full compensation to the patentee. Could you reduce the surrender of infringers' profits in case the plaintiff has not really lost anything? Another question. So we have unfair profits. So the word unfair already has some kind of goes beyond economic calculation. That would probably be a way to again assign show that the profits are somehow linked to the infringement of the asserted patent. And then 68(3)b provides for a lump sum, which is at least the adequate royalty in appropriate cases. So the first question is, it's really the floor, it's at least the adequate royalty. This would be in line with the European Court of Justice case OTK, so that it can also be more than that, which could be top up for infringers. We have to see how the UPC will deal with that. But there's clear room to go above the adequate royalty. And it's not. And then we have, what about moral prejudice? Yeah, that's the question. Can you mix the adequate royalty with moral prejudice from 68(3)a? Or would you have to integrate moral prejudice, for example, somehow into the royalty rate or lump sum compensation under 68(3)b? And also another question is, because it's adequate, it's more open, can you also take into account whether it was intentional infringement or especially blatant gross negligence or just slight negligence? That's the big question. If you read this article 68 from a German perspective, it says that the court may, in appropriate cases, award an adequate royalty. So what does this mean? Appropriate cases and the court may. Is the court fully bound by the selection or the presentation of the plaintiff in the case? If you look into the procedural rules, the plaintiff is required to indicate whether he wants to calculate damages via lost profits, infringers' profits, or royalty, but there's nothing that says that the court is really bound to follow this calculation. The big question is, can the court switch to the Article 3, paragraph 3b, adequate royalty in appropriate cases, even if this is not what the plaintiff explicitly asked for. And then the reference to the lump sum also gives the court more discretion than we would see in the German courts, even though they also have ways to, as I showed, use the causal link to make adjustments. But it seems the court in the UPC has more discretion, maybe because when this was drafted, the UK was still part of it, and the High Court in the UK has more discretion than our courts would usually had. And if this is genuine discretion, the next question is this appealable? Because at least under German law, discretion is often not fully appealable in the second stage. And at last, damages without fault. To briefly mention that, here the court can order the recovery of infringers' profits, amazingly. And you wonder, is this really the full infringers' profits that should be recovered? Then it would be like full damages or the payment of compensation. And it does not even say adequate compensation in paragraph 4. It just says compensation. And again, there seems to be discretion. And if you wonder what is compensation, that could even be full damages, a full compensation for loss suffered. But this is probably not what this meant. But there's no limitation to an adequate royalty. So it's really, this is very wide open for the court to define what is appropriate in the actual case. Just to mention, in Germany, this is not a practical problem because the standards of care for market players are so high that we hardly ever see infringement without fault. As soon as a patent is published for months, every infringement is at least negligent. An infringement without fault would lead to an adequate royalty, actually, in Germany. But in practical life, it's virtually always infringement which is at least negligent. So thank you for your attention. This is where I come to the end of my presentation.
That was a lot to take in, Dieter. Thank you very much for preparing so much. There are 100,000 questions. Let me go over the questions. Nigel Feldwell, Tom Cotter, who are you? Yeah, the international experts on damage calculations listening into you, no pressure. Trevor, Roderick. Oh my God. Okay, let's start with Tom. Tom, I apologize, I didn't take my glasses. Okay, Tom is asking, suppose the defendant made 10 infringing sales and that the evidence shows that the patentee would have made 5 of these absent the infringement, but not the other 5. Am I correct in understanding that the patentee cannot recover lost profits on the 5 sales it would have made and a royalty for the other 5? In other words, you can recover lost profits on 5 or a royalty rate on all 10, or the infringer's profit on all 10, but not lost profits on 5 and a royalty rate on the other 5.
So if these sales are distinct and you know for which sales the patentee would have made an own sale, yes, you can go for lost profits only for those 5 sales and ask for infringer's profit or adequate royalty for the other 5. But that requires that you can individually say, these are the sales the patentee would have made. Then you can have a split calculation and choose one calculation for the one and the other calculation for the other.
Okay, then Roderick McConnell says, how would the UPC calculate damages in a set case with a front license commitment? Good luck answering that. Roderick is with Continental. Maybe you look in a crystal ball shortly. Give us your best guess.
That's again very different difficult because in a SEP situation, you are usually bound to give a license at friend terms. The German courts have applied this in a way that they would only limit the damage claim to the friend royalty once the defendant has actually earned the right to a friend license. by being fully FRAND compliant and asking for a license. But for times before that, the patentee in Germany could ask for full and unlimited damages. Also, infringers' profit go all the way. But if you consider like mobile communication standards with 5,000 or 2,000 relevant patents, it's very hard to assign the profit with a product to just one of those 2,000 steps, and you would probably end up again somewhere in the ballpark of the French royalty, I would assume.
Okay, a very good old friend of mine, Trevor Cook, I think still with Bird and Bird, says is a bit less trustful that the United States has really solved this issue, and says in the SEC filings you find often financial details redacted. Then Nigel was very, you inspired Nigel a lot. Okay, what does Nigel say? Gosh, what place has opportunity lost to patentee if infringement damages reputation by sales of inferior product? He also asked, what prospect does the patentee have to require a retrospective compulsory license on full term of obligation by infringer? And what reconciliation is done regarding standard basis of valuation, i.e. cost versus income, market if appropriate?
So you cannot condemn the defendant to sign a license agreement. That's not possible. So for past times, you have to deal with this case in the regime of the infringement proceedings. But you get in the intermediate stage in Germany, where there is accounting and information. You get all the information on the sales. You get all the customers identified. You will get all the price lists, all the invoices. You can ask for all the invoices. And then you can ask for a detailed breakdown of the costs for the infringing product so that you see the actual profits. And this is very burdensome. And this is usually more information than you would ever get under a living license agreement. And sometimes this is really used just to torture a defendant, because it's very burdensome to provide the information, especially if you have to go 10 years back. And we've seen plaintiffs using this as a real tool to inflict pain upon a defendant to sign a settlement and avoid this burdensome accounting.
Already 10 years ago, I wrote as part of an expert group for the European Commission a document on how to value intellectual property. And one of the German judges was part of that expert group. And he did a survey among fellow judges and asked them about their knowledge about economics, about the valuation of intellectual property, how they would approach it across the European Union. And that survey by and large showed that there could be more done to help judges understand the economics of IP and how to value intellectual property. And yeah, and then when we were in the front expert group, which finished recently, we drew up in the previous expert report on IP evaluation, obviously because both was commission output, and very little had changed since then. So Dieter, I wonder, how do you see that? I don't want you to criticize in any way the courts, but on the other hand said, we have evidence from European institutions suggesting that judges in the end are legally trained and you push them too much into economics. It's not exactly their field of expertise. Where do you see this going? How do you see the future? Where would you like that to take further?
First of all, it's the parties. So the parties really have to provide sound economic evidence and a calculation and help the court in this way. And it is always helpful if there's a calculation by an economist, which is on a good defensible basis and in accordance with standards. And then ultimately there could be a court-appointed economic expert if it gets really complicated. The feeling at the moment is that the courts always do the initial infringement trials, but the damage trials are sometimes treated in a way, so we already decided this infringement case, so why don't you just come to an agreement and clean this up? Sometimes you get the feeling this has not the highest priority, especially also if the patent already expired. But the court could ultimately also appoint an expert to see whether the calculations by the parties are sound or what the market the market rates actually are.
Such a beautifully diplomatically phrased reply. Anything else you still want to say, or should we wrap up slowly? Anyone still, or there's still questions here? Oh, yeah. Okay, really. Howard Keith Winters, many thanks. Okay, thank you. Tom Cotter, do you have any thoughts on how the UPC or German courts will determine interim compensation in the rare cases in which they stay injunctive relief pending, sell off, or design around? I know there has been some discussion on this issue in the German literature over the past few months, but no cases. Any take?
That is a good question. So number one, I would assume the interim damages would be about the amount to cover the procedural costs, so that a plaintiff does not run out of funds to actually enforce the patent. I could imagine that this interim award of damages that is foreseen in the UPC goes into that direction. The other part is we have this in Germany now, we have grace periods, and these grace periods come with an additional financial compensation in Germany in cases where immediate injunction would be disproportionate. There has been a lot of arguments back and forth what kind of amounts these should be. Some people say it should be a deterrent almost, or a really like a fine. Others say it should just be the value of the use, like adequate royalty, and it should be taken into account when the final damages are set. It should be creditable against the final damage award. Others say it should be on top of the final damage award. So this is really an interesting question. At the moment, we cannot even solve this in Germany. Sorry.
Okay, we ran over time. Anything more, or we're good? Or?
Not for me, if there are any more questions.
Fine. I think we have also covered all. We lost a few people meanwhile. Thank you all very, very much for joining us. This was great. Dieter, thank you for putting so much work into this presentation, into such a thoroughly established slides, and for helping us understand better how things work in Germany. Thank you all very, very much for joining. Please join us again for our next webinar. We'll announce soon more details. Again, we're planning our next IP and competition forum. Please join us for that as well. It will be held in Vienna. We'll announce details on that soon. I hope you had a great time. You learned a good deal, I'm sure. And have a lovely day. Thank you all very much. And special thanks for Dr. Dietrich Kammler from Taylor Lessing for presenting here today. Bye-bye.